Let's take a look at the actual law here. Texas Penal Code 9.42, deadly force to protect property. When it says property here, it's talking about mere personal property. Items, unoccupied vehicles, laptops, barbecues. We're not talking about dwellings or businesses or occupied vehicles. Those would be given a higher status in the context of use of force law. This is the lowest status you can have under use of force law, is the use of force in defense of mere personal property. And by the way, you don't have a right to protect all personal property. You have certain privileges to protect your own property, certain conditions under which you can use deadly force under Texas law, and uniquely under Texas law, deadly force to defend your personal property, and you have a much more limited privilege to defend other people's property. Much more limited than your privilege to defend your own property. So we'll take a look at each of those in turn. So when we look at this statute, this unique statute, by the way, it doesn't have to be unique, right? Other states could also, if they wanted to, as a matter of public policy, they could pass laws that make it lawful to use deadly force in defense of mere personal property. There's nothing prohibiting them from doing that. If Texas is allowed to do it, any state would be allowed to do it. It's just the other 49 states choose to not allow deadly force in defense of mere personal property. Their public policy position is that no matter what the value of the property, human life, even of a thief, is worth more than a piece of personal property. You can agree or disagree with that. I know plenty of people who disagree, plenty of people who say, hey, that property has the financial value reflects the amount of time and effort and resources the owner of the property put into acquiring it. It represents a fraction of his life's effort, his sweat of his brow. Certainly that appears to be the position that Texas takes. And you'll note when we look at this statute that the Texas privilege to use deadly force in defense of personal property, while it has many conditions, and we'll look at those in detail, none of those conditions has to do with the value of the property. So it's not like it's saying, hey, if it's worth $100,000, then you can use deadly force. No, if the financial value is $1 and the other statutory conditions are met, that would be a privileged use of deadly force to defend that property worth $1, even at the cost of human life. Again, public policy position that any state could adopt if they chose to. So, Penal Code, Section 9.42, deadly force to protect property. Now, we're going to see all the conditions here, all the hoops, all the boxes that have to be checked to qualify to be privileged to use deadly force in defense of property. If you're missing any one of these, you don't meet the conditions of the statute, and your use of deadly force in defense of property would not be lawful. So each of these would be a target of attack. Each of these conditions is a target of attack for a prosecutor. You've killed someone in defense of mere personal property. He doesn't like that you did that. He's looking in the investigative report from detectives for some element, some condition in the statute that you failed to meet. And that'll become his target of attack if he wants to prosecute you. And if you're missing any one of them, you simply don't qualify under the statute. And then your killing was simply what? Murder or manslaughter, just an unlawful killing. So, Section 9.42, deadly force to protect property. A person is justified in using deadly force against another to protect land or tangible, movable property. So tangible, movable property is just items, stuff like we were talking about. Land we're talking about here in this context would be undeveloped land. So we're not talking about a house or the curtilage around the house. We're talking, some people live in Texas and have hundreds of acres of land, right? Just open ranch land. That's what we're talking about, unimproved property. So what could someone do to harm your unimproved property? I mean, not much, right? They can walk on it. They can be committing a simple trespass, but there's no house to invade, for example. So a person is justified in using deadly force against another to protect land or tangible movable property. And the first condition, if that is that you would have to be justified in using force against that other person under not just Section 9.42, but also Section 9.41. So the first hoop you have to jump through is a completely separate standalone statute that has its own conditions. So you have to meet all of those first. So if you're relying on 9.42, but you don't know 9.41, you can't really know if you're meeting the conditions of 9.42. So before you can use deadly force in self-defense, you have to meet the conditions of 9.41. What is 9.41? Well, 9.41 is the use of non-deadly force in defense of property. So before you're privileged to use deadly force in defense of personal property under Texas law, you first have to meet all the conditions for the use of non-deadly force in defense of personal property. What are those? Well, let's take a look at 9.41 here. A person in lawful possession of land or tangible movable property is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to prevent or terminate the other's trespass on the land or unlawful interference with the property. Interference could be vandalism, it could be theft, something that infringes on the rights of the property owner of that property. So one of the primary conditions here is reasonably believes that it's immediately necessary. So of course, the person defending the property will have formed some kind of belief that it's immediately necessary to use force to defend that personal property. But is that belief a reasonable belief? Well, he'll think so, or he wouldn't be acting consistent with it. But does his perception of reasonableness control the legal outcome of his use of force? Determine whether or not he has criminal liability for using force against that other person or not. It's not his perception of reasonableness that controls his legal outcome. It controls his conduct in the moment, his decision making. But it's the perception of reasonableness of other people not present that controls the legal outcome. It's the reasonable perceptions of police, prosecutors, judge, jurors that control the legal outcome in this case. And they weren't there. They weren't watching what happened. They have no personal firsthand knowledge. Here comes the train. About another 6-7 months at this office, folks. It's always, the train only comes through a couple blocks away at that crossing like 8 times a day. So that's good. So it's the perception of reasonableness of these other people who may not have your interest in heart that control your legal outcome. It's not controlled by you. You have to hope that they share your perception of reasonableness. So that's one target of attack for a prosecutor, right? He'll attack that, hey, you may have believed it was immediately necessary to use that force, but that belief wasn't reasonable. So let's see, what else is here? The property has to be in your possession. That's another condition here. That would suggest that you cannot use force to recover property. So, for example, something is your barbecue is stolen out of your backyard. While it's being taken, arguably it's in possession, while the theft is in progress. But what about if you don't notice it's missing until you get home from work that day, see someone stole your barbecue? The next day, you're walking your dog around the neighborhood and you see your barbecue, very distinct for whatever reason, your barbecue in a new neighbor's backyard. Can you use force to recover that barbecue? Not under this provision. The law would expect you to call the police and have the police engage in the recovery of the property, if they were even interested in doing that. They might just tell you it's a civil matter. Sue them for it. I would hope not. Second paragraph. So this is one set of conditions that would privilege the use of non-deadly force in defense of property. Next paragraph. A person unlawfully dispossessed of land or tangible movable property by another is justified in using force against that other when and to the degree he reasonably believes the force is immediately necessary to re-enter the land or recover the property if the actor uses the force immediately or in fresh pursuit after the dispossession. So this addresses now that question of recovery, but we'll see recovery is addressed in a completely separate paragraph, and it has additional conditions that do not apply when we're not talking about recovery. These are limitations on your privilege to use force in the recovery of property. First, the recovery has to be immediately occurring. So it's like the thief is dragging the barbecue out of your yard. Or he's out of the yard and he's rolling it down the street, and you see him rolling it down the street in the process of the taking, and you're in fresh pursuit. That would qualify. But seeing him cooking on it in his yard a day or two later, is that fresh pursuit? No. Are you using the force immediately? Which I presume means while the property is being taken, not if it's 2 days later. And then there's additional conditions. The actor, you, reasonably believes the other had no claim of right when he dispossessed the actor, when he took the property, or the other accomplished the dispossession by using force, threat, or fraud against the property owner. So what are these two paragraphs addressing? Well, they're addressing a repossession case. So if you stop making your car payments, the bank can send someone with a tow truck to come collect your car and take it away. That's not an unlawful taking. Now, you know if you haven't paid your car payments, presumably. And therefore, you should know whether or not your car's being repossessed. If it's being repossessed, that taker has a right to the car. That's part of your loan agreement with the bank or wherever you got your loan. So they have a claim of right to the car because you failed. So that would eliminate your privilege to use force to recover. Or the other person's using force, threat, or fraud to take the property away from you. All right, so you meet all these conditions, and now you're privileged, any set of these conditions, and now you're privileged to use non-deadly force in defense of property. Now, this doesn't say only non-deadly force, but we have to infer that it means only non-deadly force because we have that whole other statute that addresses the question of deadly force in self-defense. We just went through section 9.41 of the Texas Penal Code. Now we're back to 9.42, deadly force to protect property. So you're justified in using deadly force to protect land or tangible movable property if first you meet all the conditions of 9.41, and then when and to the degree you reasonably believe the deadly force is immediately necessary. And again, we have this reasonableness and immediately necessary qualifier in this statute. Again, is it your reasonableness that controls your legal outcome? No. It's other people's judgment call of what was reasonable. And if they disagree, you're just out of luck. So when and to the degree you reasonably believe the deadly force is immediately necessary to, and now we have a list of enumerated crimes to prevent the other's imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime. So first, notice this nighttime requirement, at least for theft and criminal mischief. So if it's not nighttime and you're using force to prevent theft or criminal mischief like vandalism or destruction, you don't fall within the scope of statute 9.42. And the other enumerated crimes here, other than theft or criminal mischief during the nighttime, the others, arson, burglary, robbery, aggravated robbery, I would suggest those are really crimes against person, right? Of course, in arson, a structure is being set on fire, but we're not really protecting the building from fire. What we're concerned about is obviously a dwelling on fire is a threat to anybody inside the building or even people in adjacent buildings. So it's really a threat of persons scenario. Burglary is invading someone's highly defensible property. So we're not talking about personal property there. And the danger of burglary, of course, is less to the property being taken than the risk to the homeowner if the burglar stumbles upon the homeowner. Robbery and aggravated robbery, of course, are thefts from a person. You're taking property from a person. They're in front of you. That's the difference between robbery and burglary. And so there's a person involved. There's a threat, a coercion, a threat of force to a person to compel them to turn over their property. That's what a robbery is. And honestly, anytime you have a threat to persons, you're not talking about a defensive property scenario anymore. You're talking about a 5 elements of self-defense, defensive persons scenario. But in any case, this is one set of conditions that you can satisfy to be privileged to use deadly force in defense of property under Texas law to prevent an imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime. And then the next paragraph deals with the question of someone who is fleeing immediately after having committed one of those acts. And again, we have an enumerated list of crimes here, but it's not quite the same list. It's very similar. To prevent the other who is fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime from escaping with the property. What's missing from this enumerated list involving fleeing that was in the first enumerated list involving imminent commission? Well, criminal mischief during the nighttime is in the imminent commission paragraph 2A, but it's not in the fleeing paragraph 2B. They've removed it. And again, here, of course, theft has to be during the nighttime. So this would be flight from theft. After committing the theft has to be during the nighttime. If it's happening in the daytime, it doesn't apply. And in addition to having met some set of those conditions, it's also required that the defender of the property believes that the land or property cannot be protected or recovered by any other means than deadly force. Isn't this, again, a judgment call? Now, I mean, for all practical purposes, if a piece of property is stolen, like your car is stolen out of your driveway, what are the prospects of actually recovering the car again? Pretty low, in my experience. But a jury would be free to disagree. A jury would be free to, a prosecutor can argue, and a jury might agree that, this property owner, he could have protected or recovered the property by some other means than deadly force. And then you don't qualify for the privilege to use deadly force under this statute. So you have to reasonably believe either that the land or property cannot be protected or recovered by any other means than deadly force, or that the use of force other than deadly force to protect or recover the land or property would expose the defender or another innocent person to a substantial risk of death or serious bodily injury.